Atachin kogenya ketestai ak tetutiet nebo Kass Mashinani ole tagetesetai gegere agobo logoiwek chetesetai eng komoswek cheterter chebo emet ole kibendi agoi kapkirwok ole tesetai eng betut nebo let interviews nebo kirwogik chemache koek kirwogik chebo kapkirwok nebo Court of Appeal ole negitepsen eng nguno ko Justice Lucy Mugwa nemache agine koek kirwogindet nebo Court of Appeal ole tesetai kibengeit nebo Judicial Service Commission kotepse inendet asikenai angot konyolu kigochi boroinoto bo koek kirwogindet nebo Court of Appeal ko ngebe eng oret agenge eng agenge agoi kebeberta nebo kapkirwok eng interviews choto bo let cheindochin Judicial Service Commission asikekas kit netesetai.
Any other?
I believe there's also the extradition laws, which are two. One, the extradition.
No, enforcement of judgments.
Enforcement of judgment. Commissioner, I'm only aware of that one.
What are the circumstances under which a foreign judgment may not be recognized and or enforced in Kenya?
Thank you, Commissioner. Such a foreign judgment will not be recognized if, in the first place, the tribunal or court which gave that judgment had no mandate to do that. Secondly, if in that tribunal, the person who is affected was not given notice to appear before that tribunal. Thirdly, if the laws of that other country are inconsistent with ours, they are not in tandem with our laws.
I appreciate. Now let's go back to employment law. A teacher has sued the Teacher Service Commission for unlawful termination of his employment contract on the ground that the disciplinary procedure leading to his dismissal from service did not comply with the rules of natural justice. Assuming that the teacher or the applicant hearing had established that his or her dismissal was unlawful, would he be entitled to orders of judicial review? And if your answer is yes or no, please give us reasons why.
Commissioner, may I request that you repeat again kindly?
A teacher has sued the TSC for unlawful termination of his employment contract on the ground that the disciplinary procedure leading to his dismissal from service did not comply with the rules of natural justice. Yes?
Yes.
Assuming that the teacher had established that his dismissal was unlawful before the court, would he or she be entitled to orders of judicial review?
Thank you, Commissioner. The fallback is Article 47 of the Constitution, which is the fair, captures the issue of fair hearing. And in that regard, the judicial review scope has been expanded in the new Constitution. And in that regard, the decision of the Teacher Service Commission can be a subject of those proceedings. And if it is found that the rules of natural justice were violated, then those orders of judicial review will be awarded in terms of Article 23 of the Constitution.
Recently, the Court of Appeal touched on this matter and decided that employer-employee relationships are matters of private law and not public law. And if that is true, what would be the best remedy for an employee who has been dismissed from service?
Thank you, Commissioner.
First and foremost, do you agree that matters of employer-employee relationship are private law and are not public law?
I would say that they are private law, but again, I would say that the Constitution requires everyone to embrace the rights and fundamental freedoms set out in the Constitution.
If they are private law, would judicial review be appropriate?
I think judicial review would still be appropriate because it's one of the orders that can be given under Article 23.
Okay, let me ask it this way. The legality or otherwise of termination of contracts of employment that have no statutory underpinning are matters of private law or public law?
The legality?
The legality of contracts or termination of contracts that have no statutory underpinning.
Those are private laws.
So when we talk about employer-employee?
It is actually in the habit of private environment.
Thank you.
Thank you, Honorable Chief Justice. Judge, a few questions from me. First, you've been asked about the advisory opinions, and you rightly said advisory opinion number 2, that was in respect of the National Land Commission. How are advisory opinions enforced?
Thank you, Commissioner. The advisory opinions are enforced direct to the Supreme Court, but only by state agencies on matters that relate to county governments.
You may not have understood my question, Judge. You know, when it comes to a judgment of a court, like for instance a judgment from your court, there is a way in which it is enforced. Yes?
Yes.
How would that judgment of your court be enforced?
Those advisory opinions given by the Supreme Court, they are binding, just like any other decisions of that court. So whatever is stated in the body of the judgment has to be implemented by the various entities.
All right, I'll take that, but I was wanting you to say they are authoritative, and hence, you know, they must be obeyed.
Yes, they have to. That's why I've said they are binding.
Okay,
yes.
Right. Now, how long have you been in the Land and Environment Court?
9 years. This is my 10th year.
Yes. So I'm sure in terms of experience in that area of the law, you're actually quite experienced. Now, the Land Control Board Act, and in particular Section 6, did make it mandatory that, or still it's mandatory that if you're seeking consent of the Land Control Board, you must do so within a period of six months in respect of a sale, lease, any transaction touching on agricultural land. Why do you think this provision was put into the statute?
Thank you, Commissioner. The statute, quite an old statute, came into force for purposes of ensuring that land is used in an equitable manner. It's managed well to prevent subdivision.
Remember, yes.
Yes. So
don't talk about the entire act.
Yes.
I want us to confine ourselves to Section 6. Yes.
Oh, yes.
That requires that you must seek consent of the Land Control Board in respect of any transaction touching on agricultural land.
To prevent subdivision of agricultural land into very small portions.
That's very correct.
Yes.
That's one. Another one?
And to prevent people from being disinherited.
Again, that is very correct.
Yes.
I'm looking for the final one.
I need to relook at the Act, Commissioner.
Right. Was it also important that we needed to control sale of land to non-Kenyans?
Yes.
All right, so that was the third one.
Okay.
And I appreciate the fact that you say this is indeed a very old statute. So the three things that we've now talked about, the first one, to avoid subdivision into an economical units.
Yes.
Has this provision served its purpose in your own view?
In my own view, Commissioner, I don't think the Act has served the purpose.
No, we are talking about Section 6. I'm not talking about... Even if it was to declare this Act unconstitutional,
Yes.
I think we would be looking at specific provisions, but not
Yes.
maybe the entire Act. I don't want to go that route. I'm just confining myself to Section 6.
I can answer this way. That section has been very problematic because it has been misused.
No, I'm not even going there.
Yes.
I am just saying, you've rightly told us that the reason why that section is there is, one, to avoid subdivision into an economical units.
Yes.
Yes? And the question, and then you have there are two other reasons. So the question is, has this section served the intended purpose in your own view?
In my own view, Commissioner, it has not. Land has continued to be subdivided
Into even smaller units?
40 by 60 pieces of
Right.
land. Mm.
Uh-huh. And stoppage of unchecked land sales?
That still continues, the unchecked, so it has still not served that purpose.
Is there any provision of the law that has come into existence that has checked land sales?
I would say the courts are, I'm aware the courts are the ones who have come in to tamper or tinker with that section to ensure that justice is done.
What about the provision that says that a man cannot sell land unless his wife has given consent?
Yes, that one.
Yeah?
Yes.
That is under what provisions of, under what law?
I'm aware section 70, I think 79 of the Matrimonial Properties Act.
Is that the one that says you must get the consent of your spouse?
Section 79 of the Land Act.
There's a huge difference between matrimonial act.
Yes, it's the Land Act.
All right.
Yes.
And the third one to control land holding by non-Kenyans? Is there any provision of the law that has taken care of this?
Yeah, there is the Constitution. At least the Constitution says that you can only, the foreigners can only acquire a leasehold interest.
So the purposes for which this section was put in place is no longer there.
It's no longer there, Commissioner,
All right.
to some extent.
Thank you. Thank you.
Chief Justice, just one follow-up from what Justice Sichalo was asking on the issue of spousal consent.
Yes.
You said it was section?
I'm thinking it's section 79 of the Land Act.
Okay.
Yes.
So what happens if a man is polygamous? How does he get spousal consent?
Ideally, all those spouses ought to give consent. But on the ground, what happens is that usually the man gets the consent from the spouse he likes most.
And what if the transaction is challenged? Say a man has 2 or 3 wives,
Yes.
and one has given spousal consent,
Yes.
and the 2 others have not,
Yes.
and they challenge that transaction
Yes.
based on the 2. Would that vitiate the transaction?
Commissioner, I think there would be a problem because the spouse who gave consent is at par with the other colleagues in that polygamous home. So the others ought to have been consulted. And so there may be a problem.
Okay. All right, thank you.
Am I correct in reading your CV, seeing that you are part of the committee that launched the Adi Sasa platform?
Yes.
Yes. So what was the purpose of the Adi Sasa platform, if you can tell us, share with us, and what challenges are you facing? Is it actually helping?
My association with the Ardhi Sasa platform came about by me being a chair of the interministerial committee on the setting up of the Ardhi case registry. That is how I came to interact with the Ardhi Sasa platform. It is helping a lot because documents, the sanctity of documents now can be ascertained because they are scanned and they are kept in a safe place, which I have even seen through that committee. So going forward, this is going to help if it's rolled countrywide.
Okay, thank you. When it comes to matters of land, which Supreme Court jurisprudence have you found useful on the issues of land, and have you applied any in your day-to-day work in court?
Thank you, Commissioner. The recent jurisprudence from the Supreme Court, I have found them very useful. That is Dina Management and Torino, because they do justice and they go to the heart of the dispute, capturing the root of the title. Because we know that land issues in Kenya are very emotive, and fraudsters took advantage of the fact that for many years people just trusted the document of title, and so fraudsters used that jurisprudence to do land grabbing right, left and center. So those decisions are very useful, and I've used them even in some of the decisions I have submitted in this commission.
Thank you.
Thank you, Honorable Chair. Good afternoon once again, my lady.
Good afternoon.
Okay, I've gone through your sample writings. They demonstrate strong grasp of law. You carefully identify issues and give coherent reasoning. Across all the sample writings, you exhibit high level of analytical rigor. The reasoning is evidence-based, measured, and firmly anchored in statute, constitutional provision, precedent, with clear insistence of proof. I would place you as your work around purposive and contextual interpretative policy, philosophy. Maybe you can tell us whether that's factual or not, especially in cases involving public land and surrender of land to public utilities, community land adjudication, and administration of administrative processes. You balance fidelity to the law with substantive justice, demonstrating sensitivity to public interest, historical land injustice, constitutional competence, and constitutional values. I would cite the example of the Giraffe View Estate Limited matter that involved the sanctity of public land. You went beyond routine application of the law in terms of developing jurisprudence, but you reinforced the place of active case management to curb abuse of the court process. So good job, Judge. So I'll ask you a question with regards to community land. Section 30 of the Community Land Act prohibits discrimination. Subsection 5 of that provision grants automatic community membership to a spouse of a community member. So there is positive and inclusive entry of a spouse once you get married into a community. However, the membership ends upon legal divorce, but for women, when that divorce, when you remarry upon divorce, or when you remarry upon the death of your spouse, you lose your community entitlement. Is this provision problematic? If yes, why? And maybe you can make reference to any constitutional or legal provision.
Thank you, Commissioner. I would say that the Constitution of Kenya prohibits discrimination, and we have Article 27 of the Constitution that factors in the notion of equality. I had an occasion to participate in the review of the National Land Policy, and that was one of the sections that we were interrogating because we found that it was actually discriminative. Yes.
I'm satisfied with the response. Thank you and all the best. Thank you, Chair.
Thank you, Chair. Good afternoon, Judge.
Good afternoon.
Yes, in your introductory remarks, you mentioned that you are part of a committee that was dealing with case management in criminal cases.
Yes.
Was that under the auspices of the NCAJ?
Yes, it was.
Okay. So what is the overriding objective of case management in criminal cases? And how do you go about achieving that?
It's just basically expeditious trials in criminal cases, because for many years the criminal cases were bogged down by processes called mentions, quitica, and they would just drag on forever, and then the small cases or minor cases were mixed with the big cases, such that even if you had a case which is not complex, you would still be in the system for ages because the courts are handling the bigger cases. So in that active case management processes, we have been screening so that the minor cases are dealt with expeditiously, and the complex cases are also dealt with expeditiously without each one affecting the other. We're also dealing with issues of guilty pleas, so that the preparation on guilty pleas is undertaken so that people don't lose their liberty when they come to take pleas. The prosecution is supposed to be prepared. People take plea, they're not put in custody, they pay fines, and they leave. And the final one centered on preparation of the trial. That is the hallmark of that committee, to ensure that the trials are made trial ready. There's proper preparation, exchange of documents, and all other preliminary issues are dealt with before the trial.
Okay, that is correct, but it speaks only to one aspect of the objectives,
Yes.
according to what your committee came up with, that is expeditious disposal of criminal cases. But there was the other aspect also, if maybe you can share with us.
We incorporated all these other things when now we started working in the committee.
Yes, the other aspect is just determination of criminal cases,
Yes,
and you
yes.
also had some guidelines on how you go about achieving that.
Yes.
So it is just and expeditious.
Yes, just and
Yes.
expeditious.
So what about the justice aspect of it?
The justice aspect is ensuring that justice is achieved through the shortest but fairest route. Yes.
Okay. So I have your performance report here from DISPOP. I don't know if you've been served with a copy.
I have seen a copy.
Yes, and you're happy with it?
And not really,
What is making you unhappy?
because I found that the rulings which don't close the cases are not incorporated in the merit production.
Yes, they normally don't add those to to merit resolution, because merit resolution takes into account the finalized matters.
Yes,
Yeah, so, but though it's captured, they do capture the rulings that you've delivered that didn't close the cases.
Yes.
So is that the only thing you're not happy about in the report?
It's
you're
the only
giving?
thing.
Okay, so now the report I have here indicates that out of the expected percentage, or the expected merit resolution, you expected to have concluded 27, but you only had 20 in the period between 2025, or rather financial year 2025-2026, but the period is between July and September 2025. I see you are a single judge in your station, but you have not met the performance targets according to the report that I have. What would you say about that?
Thank you, Commissioner. I can attribute.
Ko choto ko interviews chetesetai eng betut nebo let nebo biik chemache koek kirwogik chebo kapkirwok nebo Court of Appeal. Ole bichuto kitepsen ko kirwogik boisie nguno ko kirwogik chebo High Court ole mache ichek kobois eng kapkirwok nebo Court of Appeal. Ole netesetai kibengeitab Judicial Service Commission kotepsen ko Lady Justice Lucy Mbugwa. Ole eng tai ko kaek netai ketepse eng betutab raini Justice Samson Okongo. Ole biik alak chemokoi ketepse eng betutab raini ko Lady Justice Edwick Ongunde, Justice Joseph Kiblagat Sergon ak Justice Munyao Sila chekitepsen eng betut nebo let nebo interviews choto bo kirwogik chemache koek kirwogik chebo kapkirwok nebo Court of Appeal. Ko yekiker logoiwek alak ko eng kasarta nekotoi kampunitab mwanik nebo Kenya Pipeline Company aldaetab shares chechik cheite kebeberta 65 eng bogol ko kakobarasta kampuninotok kole chenge ortinwek alak chenyorunen rabinik cheite billion 106. Kosup ak Managing Director nebo Kenya Pipeline Joe Sang ko eng strategic plan nenywa kotete kotoi ortinwek chelelach kampuninoto chebo chobetab mwanik asikonyor rabinik akotoret serikali eng tetutik chebo bandab tai. Ko kinyoru kaaroretab logoichotok eng koindo kobun sirindenyo Samson Kurgat.
Kamwa Joe Sang kole kokonam konyor kastomaek cheboisie laindanywa nebo mwanik eng letaetab fiber.
We are on a very ambitious strategy in terms of diversification. We are looking to diversify into our revenue streams. I know Ken talked about the fiber optic. We are now in the process of lighting it. Lighting it means you are putting it active equipment. Today, in the 1,342 kilometers of pipeline, we have what we call the dark fiber. We have the telcos, mainly Safaricom, MTN, Jamii Telecom. Those are our customers today. By lighting it, that is giving it active equipment, we'll be able to get even more telcos come on board and take it to the last mile. So we are looking at by 2030, in the next 5 years, in our strategic plan, about 10 to 12% of our revenue will be coming from the fiber optic. And another close to about 8% will come from the LBG business, which is what we call the transition fuels, as well as the LNG.
Kate CEO kole wendi kora kotau chobetab mwanik kobun minutik chenootin ko biofuel.
We also want to optimize our subsidiary, which is Kenya Petroleum Refineries, in bringing in things like the biorefinery, the biofuels. These are other forms of energy that we'll be bringing on board in order to mitigate the risk we've called out. So as a business, we are very, very optimistic that the future is bright.
Shares cheite 65 eng bogol chekealdochin chemung'arainik ak biikab boror eng oret agenge nenyorune serikali rabisiek cheyoe boisionikab kamanut ako asi makites aisurushek.
The shareholder who's selling, that is the National Treasury, has made it very clear that this is how we intend to use those proceeds for development purposes, prioritizing infrastructure. They talked about roads, airports, etc., irrigation, projects. We are avoiding a situation where we're taxing Kenyans more. By raising actually these non-tax, non-debt revenue measures, it means we're sealing and containing the debt that is again going to benefit indirectly.
Ngetchin serikali shares chebo kaitosiek 35 eng bogol ngandauna ko kacher biikab boror koal shares choto ako matkosich kaiweisiet age tugul ako asikonam mogornatetab kampuninoto.
The policy objective of this particular exercise is to make sure that this asset is owned by Kenyans. We educate Kenyans about the opportunity that stands before them, meeting, this historical moment to actually take ownership of KPC and enjoy future dividends that will accrue out of this particular exercise. National asset being shared with Kenyan, beyond that conversation, we're seeing improved efficiencies at KPC benefiting Kenyans. And if you think about it, operationally, that would mean we'll see faster decision making at the company level, which would mean also, greater operational efficiency for KPC.
Kakwautiet nebo aldaetab shares chebo Kenya Pipeline ko kokinam eng betutab amut ako tetat koit let eng tarik 19 arawetab oeng kenyini ako imangu serikali konyor rabishek cheite bilion 106. Aripotenchini Kass logoiwekab emet eng county nebo Nairobi. Kainenyu ko Samson Kurgat.
Yekiker logoiwek alak chetesetai eng emet ko kakondochi President William Ruto igorta noton nebo kokoitoetab konunoik chenootin kou President's Gold Award koityi neranik chemengechen cheboto kipsomaninik. Katestai igorata eng State House Nairobi ole kanyor konunoik cheterter neranik cheite 1,252 ole kong'ololi eng igorata komwa Ruto kole indene tai serikalinyi magutik chebo neranik chemengechen asikobit kotoret eng kokimitetab bandab tai amu icheget kotokotindoi kimnotet noton nebo koyai boisionik chekonoptoi bandab tai eng emet. Ko ngeker akekas akobo ng'alalet notok kakon president eng igorata bo President's Gold Award nekatestai eng State House Nairobi.
When I articulated our ambitious vision to elevate Kenya to a first world status within our lifetime, I did so with absolute confidence in the extraordinary potential of the young people of our nation. I am confident that our youth possess the capability, the energy, the talent, and the resolve to turn our grand ambition into reality. As I have said before, and I say it again today, with conviction, Kenya's youth rank among the very best in the world in terms of our human capital development. You have the skills, you have the aptitude, the competence, and the expertise to excel wherever duty calls, whether here at home or in the global stage. It is for this reason that I am especially pleased to welcome you to this year's Gold Award presentation under the President's Award Kenya. As patron, I am deeply honored to stand with you to celebrate the extraordinary milestones in the lives of these young men and women, the recipients of the Gold Award. Listening to young Munyikai here, and he talked about a place called Jaribuni. And I have had the privilege to visit Jaribuni. And just for your information, Munyikai, the hospital you talked about, Mbudzi, right? That facility. A few years ago, I came to lay the foundation for that hospital. And I heard you talk about the dusty road and the environmental situation that was presented by that dusty road. Again, I had the privilege last year to come and commission the tarmacking of that dust road. And it speaks to what Kenya is. I never imagined that a young man from that part of Kenya, Jaribuni, would be in State House today. That tells me that there is tremendous potential in every young person, irrespective of where they come from, their station in life. All that matters is your determination, your commitment, and the effort you put in. I have said that as we celebrate this moment today, we are giving more than a word. We are recognizing effort, we are celebrating sacrifice and grit. We are celebrating young Kenyans who stayed the course when it seemed insurmountable, who showed up when it would have been easier to walk away, and who chose to do the right thing when no one was watching. As I listened to Amani and her incredible statement, I could see the talent and the wealth of Kenya's young people and what they can present. Ladies and gentlemen, the theme of today's ceremony, shaping young people's character and encouraging purposeful volunteerism, it goes to the very core of what the President's Award stands for. It reminds us that education does not end in the classroom, and that knowledge alone is not enough. In fact, it is correct to say that education is not about examination and classrooms. It's more about character and impact. What ultimately matters is the character we build, the values we uphold, and the willingness to serve what is greater than ourselves. One of the most tangible ways to demonstrate character is through service to others. Volunteerism is a powerful act, is a powerful act of hope and support. Purposeful volunteerism involves recognizing that you are a part of something bigger than yourself. It means understanding that your abilities and talents should be shared and that your community's well-being is tied to your own.
Konoto ko President William Ruto ne katesetai kong'ololi eng igorta noto nebo kokoitoetab konunotiot noto bunu President ne naat ko President Gold Award koityi neranik ak biik alak chemengechen cheboto kipsomaninik cheite 1,252 ole kosubkei ak Ruto kobo komonut neranik ak kounoto koipchin serikali anan inendet tai magutik choto chebo neranik amu toreti icheget eng tetutik chebo kanabtaetab bandab tai eng emet. Ko kibendi kamung'et nemining asiyekiwege kenyoru logoiwekab emet kong'ete Kass TV.